So there was a pretty big motion hearing yesterday, and shout out to Miranda James, drop her name in the comments. She's the one that said, hey, there's a lot of interesting stuff going on in here. It's about an hour and 12 minutes long if you want to watch it. Some parts are really hard to hear, I'm going to warn you. It's kind of hard to hear the judge and the state when they're talking, and then your ears might bleed a little bit when the defense starts talking. Frank Prito kind of blares out. But I went through it, I watched it, I agree with Miranda. There are very interesting things that are crammed into this hour and 12 minutes. I've pulled key parts to highlight for you. If you want to stick around and get more details, you can do that. Either way, make sure you hit the like button. If you've missed the news this week, there was this idea put out there by TMZ. The parents are getting arrested, right? And that warrant ends up including Courtney Clenney too. So all three of the Clenneys are charged. And it was really for the possession, the unauthorized possession, possibly access of Christian Obumseli's laptop, which the police never recovered from the penthouse apartment when they were collecting evidence. Now, the parents are arrested. TMZ kind of gives this hint that it involves evidence tampering. And then this bombshell comes out as an extra detail. You can look at my last video on it. We read through some of the group chat messages. There's a group chat that the attorneys are part of and the parents are a part of. And there's messages back and forth where the attorneys are helping to relay possible passwords and pins to try so the parents can access the laptop. They had the laptop as of September 2022, so a month after Clenney's arrest. And then in July 2023, it's noted in the warrant details that the defense counsel has their IT person try to look at the laptop, which to me suggests, hey, they still have the laptop in July 2023, and they're only starting to try to look at it. The state probably doesn't know what's going on with it. So now that you know the context, these are the key points from this hour and 12 really jam-packed, detail-packed hearing. First, prosecutors didn't push a request for a gag order. They merely say, hey, judge, can you just give us some kind of remedy? We just want to make sure certain damaging things that are unfounded aren't just being spoken into existence in the media without any grounds of it going towards proving the innocence of the defense counsel's client. So I take back my criticism. I thought they were looking for a gag order. They really weren't. They rather ask the judge for a type of remedy. And the biggest reason they want some type of remedy is because Frank Prito went on an interview and blurted out with no reason, no basis that it proved the innocence of his client that Christian Obumseli, the victim in this case, was victim of sexual battery by a family member. Later on in the hearing, we'll see that Sabrina gets up and says, hey, you know what? We've explained that. It was taken out of context. It came from text messages that the state released. But that's the reason the state wants some type of remedy for things that are being said to the press, but they are not requesting a full gag order. Interestingly enough, both sides agree that they want some type of remedy for an issue going on with TMZ. There's concerns over communication and misreporting by TMZ from both sides. Both sides agree, and the defense thanks the state very loudly for saying that there is no tampering charge involved with what's going on with Christian Obumseli's laptop. The state notes that they think the exclusive seems to have come from TMZ and that it must have been misreporting, and the defense is like, thank you so much for saying that, state. We agree. The judge agrees with both of them on this issue and emphasizes, I have concerns about some things, just some things, and how they could get in the way of a fair trial. Namely, TMZ, and we'll get into the state has said that they already sent a subpoena to a media company, that the media company pointed them to TMZ. Well, the judge is coming along and saying, this is another issue. I agree with you guys. You have this docuseries coming out on February 12th. And I have concerns about that. So I'm going to make sure I'm going to look at this and make a decision in writing and address this, among other things, on Tuesday coming up. Now, just as a sneak peek, one of the things as part of this TMZ docuseries is the parents, before they get arrested for this laptop, they suggest that they're being watched, that their phones are being recorded by the prosecution. And there will be other things in this docuseries too, if it's allowed to come out on February 12th, we'll see. But yes, the parents do have a recorded interview as part of this docuseries, and in it they talk about how the prosecution's out to get them. There's a bit of back and forth about discovery issues as well. The state is saying hey, there's some missing addresses from the witness information for the defense's witness list. And then there's also a question of, hey, where's your CV letter for your defense expert witness? And the defense ends up saying that it's the knife-throwing witness that's about to come in. He doesn't have a CV letter, which to me suggests that this knife-throwing expert that's supposed to prove Courtney wasn't holding the knife and slamming it directly into the torso of Christian Obumseli or puncturing his subaortal artery. The knife went in about like 3¼ inches or something like that. Courtney Clenney's claim is that she threw the knife from 10 feet away and it happened to land. It was a single puncture that ended up being deadly. And the defense has a reenactment video that they made with the help of a knife throwing expert to demonstrate using a pig carcass that this type of angle of penetration is in fact possible, matching what Courtney Clenney claims was the mechanism by which she threw the knife that ended up fatally killing Christian Obumseli. But there's this little bit in this hour and 12-minute hearing where they mention that this expert doesn't have a CV letter, and usually that's the standard format document that you can submit when you're adding an expert witness to your list to say that you want them to come testify, that will lay out their qualifications for testifying. So to me, it suggests that this person may not have testified in a trial before. That doesn't mean their expert testimony won't be valid, but voir dire will be very interesting, I can tell you that. And then the last point of interest, it looks like a lot here on the screen, but this is like all the back and forth, and we're going to watch it later on when we get into the deeper dive on these things from this hearing. But the defense really wants to know what's going on with the group messages, right? And so the issue is the state has now obtained these group messages between the attorneys and the family, like something like 4,300 and change messages in this group chat that span from October 2022 to months later. So the state has possession of all of this, and the defense is like, this is a quote now, are we going to need to move to recuse the entire state attorney's office for not following proper protocol for searching into communications that are privileged? Now, Courtney Clenney's parents were not represented at this time, and it is not, even if they become represented, it doesn't seem like it's going to be Prieto and Puglisi that are representing them. But those communications involve communications from Courtney Clenney, who is their client. So there's going to be some motion filed on this, and we'll see where that goes. But the tone of voice when Sabrina Puglisi was asking these questions was really interesting. She also asked that, hey, judge, even though it's fine to take the time for these other things that you're going to decide on, we do want to know, this is kind of urgent, we do want to know if mine and Prieto's phones are being recorded. So the state responds like right away, there are no wiretaps. Just flat out, they just say there are no wiretaps. And then the defense says, are any warrants being served upon us, or will they be? Do you plan to? And so the state bullet points out the only warrants served so far were for the Clenney's iClouds, the Clenney's parents' iClouds, both of their individual accounts, back in November already. They say they do plan to serve warrants on both parents' iPhones, and they're going to serve the warrant on Obumseli's laptop as well, which means they have not gained access to examine that laptop yet. They still have to serve the warrant for it. So those are your key points. If that's a good catch up and you want to head out of here, please just hit the like button and comment your thoughts on this case. Shout out again to Miranda for, being on the ball, knowing these things are going on. Miranda also mentioned there's supposed to be a court TV interview with the defense counsel. I don't know if it'll be Prieto and Puglisi, but at least one of them's going to be doing an interview with Court TV supposedly today. So maybe I'll work that into the end of the video if it's already up. But shout out to Miranda for being on the money with all of that. So in the first part of the hearing, they're kind of like, hey, we're not going to talk about the warrant stuff with the parents and the laptop just yet. Let's get to this motion to compel discovery. And some of the things that the state is pushing for this motion to compel discovery is things I mentioned already, just missing addresses, missing details. The CV letter is missing. The defense will end up agreeing like, hey, we'll provide you the retainer agreements and all of that for our expert witnesses, and our expert witness is supposed to prepare a CV letter for us. But also interestingly is this bit here, and it is really quiet. I have the captions on, so hopefully you can read it.
The studio video, for lack of a better term, one where there were 5 different takes, and there was a secondary video that looked to be outside. I don't know if that was only the defense's expert or other persons there recording it. Those people are pertinent for any discovery. The audio of the videos that were already provided, anyone that was involved in the editing of those recordings as well, particularly some videos were in slow motion. I don't know if that was a subsequent edit or anything else. That's obviously pertinent discovery.
So this is referring to more than one video here, but one of them involves the knife-throwing reenactment video. They want to speak with anyone that worked in the production and possible post-production editing of this video that they recorded for the reenactment. And the defense is going to end up saying like, hey, we were there just was no audio as part of that recording. But the state still has the right to ask to call anyone who worked on the production of that video as a witness.
I can't tell whether the witnesses that were listed yesterday were experts. I'm not sure who they were, but you guys can
So now this is important because one of the witnesses is actually a neighbor.
Under 3.220, the defense has no obligation to disclose witnesses unless we intend to call them. It's that simple. The witnesses that we listed recently, we intend to call.
Listen to his tone of voice.
Well, the two experts that we listed, I think a couple weeks ago, yesterday I amended with 4 civilian witnesses. I believe it's 4 in total. Those are civilian witnesses, one of which, Arthur Cupp, we identified through body-worn camera that the state provided to us, so that person was readily available to them as well. He gave a statement to police, so his statements are contained therein. Any interviews that we've conducted of these witnesses, we will get those.
I believe Arthur Cupp is a neighbor that previously witnessed, and he did a local news interview. Let's see if I can pull it up.
Answered questions after I said there.
See, because I think it was this guy, this neighbor, that they might be referring to. Oh, is he in here?
One neighbor who tells me that he has a very clear view of the couple's apartment said a week before the stabbing, things were off and that Clenney was the one getting physically abused.
I could not tell if it was open-handed or closed-handed, but he was swinging at her.
Police say in the past 3 months, they've responded to multiple disturbance calls at the couple's apartment.
So I think that's why I think, and I think this is the same person who we just saw in this video. I could be wrong, but I think they are identifying an Arthur Cupp as a witness, and I think it's this guy that had given this local news interview months ago already, saying that he was the one who saw through the balcony that Christian was the one hitting on Courtney. And so on that point, I want to jump forward here a little bit to 3721, because Frank Prito is going to complain that the state is concerned about us talking to the media, but they have no concern about their own press conferences and the way they're framing things without context. And the state isn't requesting things that would make our client, Courtney Clenney, look innocent. And then the one example they give, the one example of this thing that could make their client look innocent is this one statement from Arthur Cupp, the neighbor.
That the state was facing by listing all the discovery and media outlets picking pieces of, oh, send me this video, send me that statement, send me this interview. Nobody wants to request a body-worn camera of the defense witness, Arthur Cupp, saying that she saw Obumseli beating Courtney. Nobody advertises that. No media outlets are covering that for the defense. The state's not putting that out there either.
So you notice how he pantomimed what Arthur Cupp is saying he saw happen, right? Right? And this is the only thing he's saying. If you want to play this, he's not going to say, like, there's other videos of another person witnessing. This is the only example he sticks to. So if we take a pause right there and say, is that your only example? Is that the only thing out there? And how compelling is that really when we have at least one video of, and a video of it actually happening from Courtney Clenney with the physical violence going to Christian Obumseli. And then we have an eyewitness account, but not a video recording where the eyewitness says, it was actually the other way around. It was like a couple days right before this all happened. I saw it on them on the balcony, and it was Christian hitting Courtney. So you're going to have, the jury could have video evidence that they can see of Courtney doing it, and then only this witness testimony where he's relaying I witnessed it. Maybe it'll be compelling, but it's different to see something with your own eyes, right? Especially if it happens more than once, and then you just have one person saying, well, one other time. I don't know, guys. But I just noticed that was that little detail that the defense hitched themselves to two different parts of this hearing. And it's the only example they really give of a video that they say they wish the state and the media wanted to get their hands on because it looks good for Courtney. And pin the fact that Prito pantomimed the action on a court hearing that he knows is being televised and streamed. So to close out the details on the motion to compel discovery, they just talk about Mr. Quinn. The state is requesting communications. We're in communications between the defense counsel for Courtney Clenney, any written communications between them and Mr. Clenney, Kim Clenney. So the judge asked them to file that in a separate motion. We don't get any type of ruling on that. Pretty much the rest of this video time spans is going to focus on a motion for a protective order and a gag order. Now, to understand the difference there, the protective order is the idea of, hey, this specific exhibit, do you think this type of thing can be put out for public record? Or should it be sealed for, indefinitely or for the duration of this hearing or till it's further unsealed by the judge? With something like a gag order, that's a request for some type of remedy or protection about someone being able to speak about something publicly to the press, whatever the case may be. And throughout this time period, you'll kind of see those two issues go back and forth, the idea of a protective order and a gag order. Because again, if something's not sealed, there's no protective order protecting it from becoming part of the public record because Florida is a sunshine state, the media can come and grab it, they can go talk about it, And then Court TV can say, hey, Prieto, hey, Puglisi, there's this thing that we obtained through public record. Since it wasn't sealed, it wasn't filed under seal, there's no protective order keeping it from us in the media or the public's right to access it. Do you want to come and talk about it? So now that something gets released, the defense will get asked to come do an interview to speak about it. And then when they oblige, they've gotten in some hot water because it seems like they may have overstepped their bounds, although they disagree with that characterization. So you're going to see a lot of back and forth, but really a good 10 minutes of it is just debating like, oh, the state filed a second petition for a protective order just before this hearing, just yesterday. And the defense also filed a previous motion to suppress, but they withdrew it and haven't returned it amended at this point. You're going to see the state complain that there's no unringing the bell and the defense is ringing the bell. And then you're going to see the defense complain that the state is, well, you can't put the cap back on the toothpaste tube after the toothpaste has already come out. So they're both like alleging the same thing back and forth. And now the issue is the judge needs to find an adequate remedy. When the trial started, the defense filed a motion for injunction for a protective order that would request the court review every individual piece of discovery and make an individual ruling on each piece of evidence before it could become public record. That's not practical. It's not tenable. For example, if we just look at the text messages that are a new big evidence issue, the group text messages, there's something like a terabyte of data of discovery relating to this whole laptop thing, communications about the laptop, 4,300 something messages. Can you imagine if the judge had to go through and pick piecemeal what parts of it were able to go under seal or not seal? So at the beginning of the case, she had denied that motion for injunction for the protective order.
The state has, on purpose, because of the attention created by this case, specifically by the respondent and his client, not sought to limit public speech by anyone.
So if you hear that, this is the state saying, we know this is a high-profile case. Basically, we don't want to get this wrong. We've purposely made sure we didn't try to restrict anyone's free speech. So they're also making a reasoned argument here, like the defense is choosing to telegraph their case in public. They're going to say, why would we fight that? Because it gives us a strategic advantage. We know what they're going to try to argue at trial. So why would we fight that, Judge? We're not the ones trying to restrict the defense's free speech. We're learning new discovery because they're talking about things to the media.
So to that effect, the state has deliberately sought not to raise this issue. One, as a matter of professional courtesy. Secondarily, because there is a great public attention and interest in this case.
So they're like, look, there's 3 reasons we want them to be able to keep talking. We're not trying to stomp on anyone's First Amendment right. But please take us seriously when we give you this one reason why, this one concern that we have.
So we sought no interest in limiting the defense counsel from telegraphing their case. The defendant's attorney walked a very fine line several times, as we outlined. There was this court's hearing on the Arthur hearing, where he made inappropriate remarks, the state objected, of course, his thing. Then several interviews, remarks the state would not have, suggested making a fine. The respondent walked up to the line when he called the victim, who's deceased, is unable to defend himself, an animal. And there's a particular history that comes with.
So if you caught that, he's like, but we have specific things that we want to make sure they can't just go out there and be saying. One of them is statements like the defense counsel calling the deceased an animal.
Humanizing people, and the big elephant in the room is the racial disparity. But the state nonetheless restrained itself. But that crossed the line, the respondent crossed the line, when he gratuitously, and I don't know if the court has reviewed the video, but it's been available for the court, not a response to the question, not prompted.
So unprompted, without reason, it has nothing to do with proving the innocence of their client. They're going to say something in an interview that's just unsolicited and they should not have said.
No other reason. Just volunteer that the victim was sexually battered by a family member. That's not appropriate. That achieves no goal. It is not asserting the innocence of his client. It is not saying the evidence will show that his client is not guilty.
So the point here is, it's going to go on for a few minutes, but what he's going to conclude after making his argument for a few minutes here is, look, we tried to keep it professional. We tried to resolve this without having to calendar it. But the defense has engaged in conduct that requires attention. Now, if you saw my last video where I mentioned Sabrina Puglisi went on and was like, hey, they're trying to have, they're trying to calendar a hearing to subject us to a gag order. I kind of threw them a bone there and I was like, well, I don't want to see that. But now I know it's a very specific issue. They have grounds for it. It's a great argument. I totally support this, what the state's saying here. That's just me. You can disagree with me. So now I'm looking at that interview like, okay, so Sabrina was complaining that they calendared a hearing. She specifically used that language. They're calendaring this hearing. Now we've got to go to court about it, meaning today, what we're watching now. The state will say like, hey, we filed a petition to show cause. It's just a matter of record without calendaring the matter. But 3 months later, the defense brought it up in court. They still didn't want to give us the professional courtesy of not walking this very thin line, calling the deceased an animal, alleging that a family member subjected the victim to sexual battery with no relevance to defending the innocence of their client. Now we think this needs attention from you, court. That's why we're calendaring it. So when Sabrina gave that interview and made that, oh, they're calendaring a hearing about this, she knew that it was already like a courtesy, professional matter of record, that the state filed a petition on this type of issue, but chose not to calendar it, which meant it wouldn't have been a part of a televised motion hearing. But because they kept pushing the line anyway, now the state's like, we kept it professional off calendar for like 3 months, but this really needs attention now. Then Sabrina complains in an interview that it's being calendared, when the state, seems to me, I agree, they tried to not calendar the issue. What do you guys think of that? They're also going to make some mentions of, hey, we discovered the idea of this knife throwing effort not from counsel, but because of, something we saw on TV. We discovered the reenactment video from the respondent's co-counsel going on TV, not because of discovery. And now we have to make these motions for discovery, and that's wasting the time. They're going to say this trial's been going on for like 17 months since the arrest, and we're still having discovery issues when the defense clearly knows this stuff exists because they're talking about it. That's how we're hearing about it, when they could have just turned it over to us. So that's a summary there of that part. This is kind of like a lot of like dry, reasoned arguments. I think I pulled all the good details out of that. But again, if you want to watch it in full, it's over here on Court TV. The link will be in the description. But let's get over to the TMZ stuff. So now we're going to get into a kind of middle area where the state made a really reasoned argument. The defense has had like some points, but they haven't really made their full response yet. But the judge is going to say like, hey, I heard about this TMZ thing. Like, what is going on with that?
Also happens in Docuseries or TV show in the making prior to the trial in this case, where the officers and the witnesses are allegedly, interviews are being sought from everybody. I had also seen it online.
Yes.
And was very surprised to see that.
I can address that. So the state has not ever been approached regarding from TMZ regarding our comment and participation.
So the state has not ever been approached by TMZ regarding their comment or participation.
This docuseries.
And you notice the judge brings up this TMZ issue. Like, hey, before we move over to the next thing or the defense's response to everything you just said, we should also talk about this TMZ thing now because it's related.
We learned about it almost contemporaneously with one another. We served a subpoena on the defendant's management company for behind-the-scenes information, contract, etc., premised off of the respondent's statement that she was allegedly human trafficked.
So they subpoena the respondent's management company. Management company is going to say, no, it's TMZ, go to TMZ.
So we expect that might come up in trial, so we might have to rebut that. The counsel for that company informed us that they were approached by TMZ regarding a docuseries that they wanted to interview his client. At roughly the same time, and the court has the emails in our exhibits, the city of Miami's public information officer received a request from TMZ.
So Brian Andrews wants to speak to the lead detective. Which, by the way, if you want to go back to like the initial hearings, back like the bond hearings back in November, there was a lot of testimony from the detective. It was a long listen to, but there are some like, a little bit of shoddy work. Not the worst, but there's a little bit of stuff you could kind of poke some holes in. Mainly with mom's texts.
And 30 hours or so later, we get a response, essentially neither accepting or denying anything. And about 10 days later, we find out from Lexington Capital that on that date, the respondent sat with the defendant's co-defendants for interviews. And there's actually a few.
So by defendants, co-defendants, they now mean the parents, because now they are charged with this one crime involving the laptop.
Matters that TMZ aired parts of those interviews already as a apparent teaser. So, the damage has been done. There's nothing for the state or the court could have done.
And this is probably the most important bit here.
Part because the reply was being drafted and matters have been developing. TMZ, I believe, was the first to report the arrest of Mr. and Mrs. Clenney. And that reporting stated that they were arrested for tampering with evidence.
So TMZ was the first to report it. And that report, said, hey, the parents are arrested for tampering with evidence.
Clearly the arrest
But
warrant don't state that. Clearly the facts in the arrest warrant don't state that. Clearly the state's information that was filed and sealed at the time didn't state that. That was not a correct report.
So this is the state saying that what TMZ reported about the parents, who are now the co-defendants of Courtney Clenney on this one laptop charge. And obviously the parents are witnesses for the defense, right? The state is the one saying first in this hearing, TMZ is misreporting. They are over-reporting something that we didn't say. It's not in the arrest warrant. They're just saying it and they're citing it to a source of direct knowledge. We're concerned because we think that only source of direct knowledge is from the respondent's side.
An inference of whatever was told to the Clenneys on scene because they weren't told that they're charged because they refused to speak to the officers. So given the intimate personal relationship the respondent's been having with TMZ regarding this docuseries, the state has obvious concerns that there's potentially going to be something televised, and particularly the state's concern, because it was alleged by the emails, is that this is being telegraphed from a particular perspective. And the state does not get to air an infomercial of the defendant's guilt before trial, so the defendant should not be either. And that's inappropriate conduct that the court should be alert to.
So they make that argument like, hey, we don't know where TMZ is getting this not correct information that this involves witness tampering. We have not said that on our end. So we're concerned it's coming from the respondent. The respondent is going to respond to a few things. Remember, the defense has made like 20 minutes worth of a reasoned argument here. Now, the defense counsel has to respond to each of the bullet points that the state has already raised. I'm going to try to jump forward to each part, but make sure you're pinning what he just said about TMZ. Because Sabrina's going to be like, I'm so glad you said that because we didn't say that either, and we don't want them to think that there's tampering from our witnesses and our client. But just the nature of the way that these hearings work, it goes like first bullet point to first bullet point, it jumps back and forth. The first here is, so first Prito says like, hey, some type of protective order is appropriate because, we tried to file one in the beginning because we knew what's happening now was going to happen. If something comes in as evidence, the state puts something forth as evidence, the press is going to come right along and say, hey, under Chapter 19, you've got to give us this. We're a sunshine state. And then it's going to be out into the media. It's going to be missing context. It's going to unfairly prejudice our client's right to a fair trial. And then they add in some other reasons to bolster that argument.
The defense side being barraged by the media from day one. And, the state saying they can't unring the bell. Well, you can't put the toothpaste back in the tube either. And that is why at the onset of this case, I sought a protective order to limit the discovery being released under Chapter 119 because I knew this was going to happen. The state aligned themselves with the Miami Herald and fought me on that.
So he's saying the state and the press both got together and fought the protective order when it was motioned for.
All I was seeking was
the injunction.
For the court to review discovery prior to it being released under Chapter 119, not a complete gag order at all, because the writing was on the wall. My office probably received 15 calls as soon as the arrest was made. I wanted to limit this, and now the state can't have it both ways. It's the pot calling the kettle. They know under Chapter 119, when they fought the initial disclosure of discovery, that this was going to be a subject of great media attention, and they were happy to list all the items in discovery in detail, and then began the onslaught of Chapter 119 requests made upon the state to get all the video, to take it back when Ms. Clenney was arrested and kept.
So they're going to talk about the press conference here.
A very carefully crafted press conference was done. Ms. Rundle's been in office, I think, over 30 years. She was my boss. She was, I think, your boss at some point. They're a very sophisticated state attorney's agency, I think the second or third largest in the country. They have a public information officer. They knew when that discovery was released that they were going to receive tons of requests for the videos, the audios.
And I want to be clear. You've heard me point out, if you've watched any other comment I've made on this, yeah, I think that whether it's wrong or not, like that's not really what I'm getting at. But the prosecution, the state did come out and make this like very strategic press conference where we know we're arresting Courtney Clenney. She's waiving extradition. She's coming over to South Florida from Hawaii, where she was actually arrested by local police. And we're going to do this press conference, and we're going to show this elevator video. And we're going to act out how she stabbed him. Even though she's saying she threw the knife from 10 feet away, we're going to motion out and give this visual of, stabbing down to the torso. And he's pointing out, like, hey, it's more than just us not wanting the press to be able to access things like they're rightfully able to through Chapter 119. It's how they are able to strategically present and package things, the press and the media. But they want to restrict our right to respond to it in the media. This is the argument that they're making. Not saying whether I agree or disagree or think it's all the way valid or what. Watch what he says. Watch what he specifically complains about.
Which are subject to suppression, but that's a motion for another day. But they knew it was going to be released, and they know that every time a media agency makes a Chapter 119, they're going to throw their hands up and say, well, we have to comply with the Sunshine State laws under Chapter 119. We're not giving it to the media. But they knew that from the beginning that would happen, and now they're hiding behind that to say it's the defense that is putting all these things out there. They let the toothpaste out of the tube, and we're trying to put the cap on it. Why? For example, the video released at the press conference of Ms. Ronald standing there going like this.
Right here.
We take issue with that. We don't think the facts.
It was very quick.
Why? For example, the video released at the press conference of Ms.
Watch
Ronald
his hands.
going like this.
Standing there
We take issue
going
with
like this.
that. We don't think the facts support that.
We don't think the
elevator
facts support that elevator video.
An artery is within the human heart. The chief medical examiner further determined that the knife entered Christian's chest in a downward angle to the depth of 3 inches.
So that's what he's complaining about, is that, hey, but to me, she's citing someone else determining that this motion happened. She's not personally just asserting her opinion as a matter of fact during this press conference. That's how I'm looking at it. But that's what Preto's arguing about here, is that motion. But in the beginning of this hearing, and sure, this hearing probably won't get as many eyes on it as that press conference did, but we see him pantomiming, oh, why doesn't the state and the media care about this video of Arthur Cupp saying that Christian Obumseli was doing this to Courtney Clenney? So he's complaining about the pantomiming in this press conference here, but he's also in this hearing going like this. Well, we don't have a video of that. So, just saying.
Because why? It's great for the state. The media's going to love it, but they don't supply it with context, which is the danger. That
He's going to bring up Arthur Cupp right here. This is the clip we watched.
Picking pieces of, oh, send me this video, send me that statement, send me this interview. Nobody wants to request a body-worn camera of the defense witness Arthur Cupp saying that she saw Obumseli beating Courtney. Nobody advertises that.
You just got done complaining about someone else pantomiming what they're saying a medical examiner determined. But now you're pantomiming. It's not a video of Christian Obumseli making any there's no video of this. There's just an eyewitness account saying he saw Christian Obumseli hitting, in some way, Courtney Clenney on their balcony, which they probably thought was a private moment, and he just happened to oversee it. So he's complaining about what a medical expert determined was the motion of entry of this knife. But then he's pantomiming words from an eyewitness in the same breath where he's complaining about press access and contextualization. So I think you guys kind of get the point of where I'm getting on this part of the motion hearing. Another bullet point response worth looking at.
To show Mr. Obumseli was a victim of a sexual battery are in the text messages they made public.
So he's saying, oh, the state complained, but by the way, we didn't just pull that out of nowhere. It was in the text messages that they made public. Now, I didn't really see that in the snippet of text messages I read. Maybe I'll look at them again. But if you guys are aware of maybe something public about these text messages where they're saying they saw this basis for sexual battery by a family member, if you guys want to let me know, because I'm confused. I don't know what that's referring to. I might have missed it in those text messages. Maybe there's more text messages. The next bullet point that I want to jump to of the defense responding to something the state said is this TMZ tampering of evidence. So Sabrina's like, I want to thank Mr. Quinn for mentioning
recently, within the last 48 hours, there's been news media coverage about the Clenneys being arrested, and one of the things talked about tampering with evidence. And he himself just now said on the record, which I'm very happy for, about the fact that this is not a tampering case. There's no evidence of it. But you know what's going on in the media is that Mr. Prieto and I are being vilified as being said that we are instigating this and we had our clients alter the computer. That's what's out there. Imagine now we have to try to defend ourselves from what's going on. So we can't control what the media says, but as he said, we have to be able to respond. And so we have a motion to compel, which I know we just filed it last night based upon what's going on in the new thing. You probably don't, and they haven't had a chance to respond. We're going to ask you to try to put it on.
Now, this is going to be about, hear the intensity in her voice, and then listen to what this motion to compel is about.
On as soon as possible next week, because our whole text communications were reviewed, and it is our whole defense laid out in the text communications, which were subject to this new charge. That's how the whole case started with this new offense. It's based.
So our whole trial strategy, our communications about all of this are in stuff that the prosecution, the state now has access to. Our whole case.
On reading work product that we had. And so now I don't know who had read the text from there. We're going to ask the court to do a protective order because God forbid that discovery comes out and now they can Chapter 119 request.
And now the judge has kind of been a little bit lackluster in some of her reactions, but here the judge is like, you can see her get more animated. She's already she's seeing ahead of what Sabrina is explicitly about to say. The judge is like, and now you're worried that with Chapter 119, the media is going to come and request this evidence, and all of your text messages, including your trial strategy and possible privileged communications between you and Courtney Clenney that may be mentioned in these group text messages, could become accidentally, not rightfully so, released to the media. So not only does the prosecution have a window into your whole trial strategy and possible privileged communications, but now we have to make sure the media doesn't get access to them. This is a pretty big deal. Whether you want to say that the attorneys are doing something shady or not, you're still not supposed to violate attorney-client privilege. And then there's also the concern, of course, about a fair trial for the defendant, who has a right to a fair trial if the entire trial strategy is seen by the state because it wasn't filtered appropriately through discovery.
All of our text messages, but there's a lot of issues to deal with. As you can see, it's not your normal case. So we are just making sure we calendared this only to make sure that we're not being prevented.
And so the state's going to oblige. The judge is going to be like, look, I need some time to go over this. And there's the state's going to be like, yeah, it's like a terabyte of data. We'll have to work together with each other. If something comes up, we'll make sure that, hey, there's an injunction here. It's pending. We need a decision. We can't release this. So the urgency here is what's notable. The next bullet point here is, so we heard the state say, nobody's approached us for comment.
Concerns the court had. Well,
I know where I was going anyway, but go ahead.
yeah, so the Docuseries, I can tell the court, yes, we were approached and interviews were had.
So we were approached, we did do interviews, but we were approached. They contacted us. He's also going to go on to say that there's nothing in there.
We were approached because somebody wanted to put a neutral
That's the reason we were approached. They want to put a neutral message out.
Not just the let's call it the crazy elevator video side. They contacted us to put out a neutral documentary about what the family perceives is going on here and the evidence that the state already put out in the public. There's nothing there that the state didn't already put out through their.
So they're saying there's nothing there that the state didn't already put out, and they approached us.
I'm asking the court to take no action on this petition, deny it outright, because we have to, when more discovery comes out, we have to have the ability to push back. So, for example, Court TV calls us almost twice a week, and we don't go on very often.
So they're always asking us for our statement. We don't even take up all the offers, the invitations to go and talk.
We do go on. It's because they had a panel of experts analyzing video and commenting about what these quote-unquote experts think the video shows. And that is improper for us to remain silent about. For example, the elevator video. Nobody talks about how that elevator video, the elevator goes directly into the client's apartment. Nobody talks about this gentleman having the only fob. And if we are not able to push back at the level that we've been pushing back against the media mischaracterizing the state's discovery, that will materially prejudice our client. And I haven't heard any, as Judge, we presented at our motion to get some type of limit on or filter process for the discovery in this case. We had empirical data of the number of hits that the elevator video got, and we had our IT expert conduct searches, and we gave.
So they're saying when we make a complaint about the coverage and how it prejudices our client, we're coming with empirical data. We're showing how many times this elevator video has been searched for and viewed online. But now when the state is complaining about us doing these court TV interviews, which I'm telling you right now get no many, he's going to say, and I'm assuming that's probably true. This court TV interview that they're going to do or did do, all of them combined, aren't getting the amount of views and coverage and hits that the totality of this elevator video has gotten. And additionally, the state's not presenting empirical evidence to back their request and justify their request to ask us to stop doing these court TV interviews. We came with the data about this elevator video. They don't have data about this court TV stuff. We have a right to continue to take these invitations, even though we're only doing it once in a while, because they're putting experts up there to analyze this evidence. And if we don't go and respond to it, it's unfair to our client. So that's kind of the argument being made there. At a broad level, it makes sense, but it's still, the core issue the state has is you guys walked a thin line by going up there and saying that Christian Obumseli, the victim, was a victim of sexual battery by a family member. That wasn't prompted by an interview question, and you didn't say like, hey, here's why it shows that our client is innocent. It was not relevant, and you volunteered that information unsolicited, with no solicitation. So the defense's argument here is like kind of okay in theory, right? But they're not addressing the very specific grievance the state had. They're just giving things that sound like a reasoned argument in open context. And I love this part of the state's rebuttal to this rebuttal.
Not put out any narrative. The state just produces evidence. We do not release statements. We speak in court. A person obtaining any sort of evidence, such as autopsy photos, and mischaracterizing that autopsy photo is their right as a citizen in Florida, period. We cannot.
You see that, guys? I'm in Florida, if you don't know. He says, hey, it's any citizen's right in Florida to obtain and mischaracterize something. That's me. I have that right. So, I thought that was funny the way he worded it, especially since I live in Florida. But he's basically saying, hey, we're not the ones going out there trying to spin some PR narrative or anything like that. We have a duty to produce evidence, and since it's a sunshine state here, if the media or a citizen requests that information and they go on to mischaracterize it, that's not the state's fault. Certainly fair enough. So, it's my individual right here in Florida to obtain evidence and mischaracterize it. So right at the end, Sabrina Puglisi is going to be like, hey, we're dealing with a lot of sensitive information today, and one of the things I really want to make sure we get an answer on is this big question.
The things I'd like to at least know right now is, are Mr. Prieto and I, do we have our phones being recorded, our conversations recorded?
So, we'll give you a copy of yours. State, did you say that you have already filed another motion to compel, or
No,
was
Judge.
this response to their motion?
Yes, so the court, I raised today that Mr. Clenney is listed witness by the defense. The state is entitled, just like the defense would be, to memorialize statements by a witness in the case. They have no obligation to list the witness. So if he had not been listed, he would have no obligation to provide the statement. But they are in possession of statements by him.
Can you get anything that you think that you were entitled to in a motion?
Now, the judge is going to say, put it in a motion, but from this point forward, I want you to watch the judge's body language, because again, she's very animated. She's very into this part because it's pretty serious. It's going to involve protecting what could be or could become attorney-client privilege.
Judge, I will additionally say, though, I don't think we can hear that motion until after, because he is, because he has a charge now. He's going to have a lawyer.
So he's charged and he's currently unrepresented. Watch the judge.
Yeah, so, and that's what I was going to say.
She says he's not represented.
Judge, and I think that matters also. The collateral is related to the defendant's motion to compel last night. So I think what would be wise, just to evaluate some drafting time and how long it would take to respond. We could respond.
And then they're going to ask some time. They're like, we don't know if we can write this all up by Tuesday. And then so the defense is going to be like, all right, we get it that this stuff's going to take time to weigh on, but please, 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 this one thing, please, please, please.
If we don't know how the filter team was, are we going to need to move to recuse the entire state attorney's office for not following proper protocol, for searching into communications that are privileged?
Did you see how slow that blink was right there? Look at the judge's blink. And I'm not trying to like super body language it here. See if I can pick a good spot.
Searching into communications that are privileged. There's a lot of issues here, but I really want to know, because Mr. Prato and I were named as principals in their warrant. Are we being recorded, our conversations? Can they at least answer that today?
Okay, so that's the urgency of what.
Judge, there are no wiretaps. These were pursuant to 2 warrants that we
So the judge's face is like, can you just tell them? And then the state's like, Judge, there's no wiretaps.
provided counsel and are part of the public record.
And can we also make it clear, since the media is listening, that this is not a tampering case? There's no allegation, at this time at least, there's no allegation that anything was done to this computer to tamper with it.
So Sabrina's saying, say it louder for the people in the back.
We recovered the laptop on Tuesday that should have never been in the defendant's possession. So we can.
That's not
true.
All right, so here's what we're gonna do. It sounds like you need more time to respond to that. They have given you their assurances that you're not being recorded right now, which takes away that urgency.
Or any warrants being served on our iCloud accounts or any of our personal communication devices.
There have been no warrants served on anything regarding Mr. Prate's or his witnessing. The warrants have been served regarding Ms. Clenney's iCloud, Ms. Deborah Clenney's iCloud, Mr. Clenney's iCloud that was kind of commingled with Ms. Clenney's iCloud. That was served in November. We don't have any of those matters pending. There will be upcoming warrants on both of Mr. and Mrs. Clenney's iPhones. There is an upcoming warrant on Mr. Obumseli's laptop as well.
So warrant coming up for the iPhones for both the parents, and then warrant coming up for the laptop. But there's nothing. He's like, no, there's nothing. No warrants coming for the attorneys. There is one last thing here that comes up. It's a small detail. The defense brings up a subpoena that the state filed against their expert, the defense expert. They want to file a motion to quash this subpoena. The witness has their own representation, but they're like, we are the ones that we think we need to file the motion to
Until that
quash.
gets done, we would move to, hold off on any kind of interview. He is being represented by Jude Fechadomo, so, but we believe, because it's our defense expert, that it's us who would be doing the motion to quash. So
just get it filed before the 9th.
Yeah.
So file that, and then the judge is going to say to the state, just, hold off on, if the time comes and there hasn't been a decision here, the defense hasn't been able to file that motion to quash yet. I haven't ruled on it. Just hold off on holding that interview with this witness till I make a ruling. That's it. So those are the key takeaways from this hearing, you guys. It seems like they might be doing a court TV interview today, the defense counsel, at least one of them. So we'll see if that happens, and we can talk about that. The links to this full-length hearing are in the description if you want to go take a look at that. But again, some interesting details in this jam-packed 1 hour and 12 minutes, and that gets you up to speed with what's going on with the Courtney Clenney case and the case now of her parents and a laptop. So, and no involvement of the attorneys as far as warrants or charges for what was initially represented as possible evidence tampering aided by the attorneys. Clear that record a little bit. You guys let me know your thoughts on everything here, and you guys take care.